To register a trademark, if you want trademark protection in the UK, you can apply to get protection in the UK by one of two means. One is directly via a UK national trademark application, or secondly via a European trademark application. Because a European trademark application covers all the territories which are member states of the European Union, it also automatically covers the UK. Now, the process for applying for trademark protection in by both routes is pretty much the same, in the sense that you have to fill out an application form and pay a fee. Identify the mark which you wish to have protected. The mark has to be graphically represented. So if it's a word mark, you put in the word. If it's a logo, you put the logo. If it's a smell or sound, you have to represent that. I guess a classic example is the polo mark, where it's used for both mints, cars, and clothing, and it's owned by different proprietors. Once you apply for trademark registration, it gets examined by the respective intellectual property office, where they will do a search to identify marks which are similar to your mark, identical or similar to your mark, and also list identical or similar goods to your mark. They will not object to your registration on the basis of those marks, but they will notify the third parties which have the rights in those earlier marks of the fact that you've applied for a similar or conflicting mark. What the Intellectual Property Office would refuse your mark on is on absolute grounds, in the sense that if your mark is descriptive of the goods and services, for example, clothing as your mark to cover shoes, shirts, t-shirts, or if it's deceptive or might be perceived to be deceptive by the public, for example, 5-star for hotels when it's a budget, where there's against public morality, and the other few reasons as well. But that's the main reason for the office to object to on absolute grounds. If there are no absolute ground objections raised, or if there are objections raised and you overcome them, then it goes through publication, where a third party will be given an opportunity to write to the Intellectual Property Office and object to the registration of your mark. If there's no opposition to your mark, then it will proceed to registration. The whole process from start to finish can take about 6 months on average. Once registered, it can carry on indefinitely, where you pay renewal fees every 10 years.